And my name is Sharon Blackman. I'm the Director of Training for Families Helping Families of Greater New Orleans. Today's presentation is one of over 100 of these training opportunities brought to you every year by Families Helping Families of Greater New Orleans, and they're always completely free of charge. So welcome, and we are very glad you're here. Before we get started, I have a few little housekeeping things to mention. Please make sure that your mic stays on mute. Sometimes we get extraneous noise, so please keep that on mute. Camera use is totally optional. It does not matter if you have your camera on, as far as we're concerned. We will have some Q&A involved. You can feel free to type questions in the chat as we go. We may be able to pick those up, but if not, we'll certainly have some time at the end to be able to discuss and ask questions. We're working on getting you a copy of the slide deck later on. We discovered that it was password protected, so we're working on that. It may be later than normal when I send that out. Also, I will put a link to a very quick survey in the chat box toward the end of the presentation. If you would please take a moment to give us your feedback. We do require that for our funders, but we also just really like it. Like hearing from you, anything that we can do better on our offerings, and anything that you enjoyed, of course. Also, if you need a certificate of attendance for today's presentation, you may request that in the survey. So click the link and complete the survey, and you can request a certificate of attendance in that. Our speaker today is Luz Lopez. She is a senior supervising attorney with the Southern Poverty Law Center. So Luz, welcome, and thank you so much for being here today.
Well, thank you so much for having me, Sharon, and for hosting this conversation. I appreciate you. And thank you all, those of you who've joined. I am here really as a placeholder for my colleagues, Lauren Winkler, Ashley Dalton, and Sophia Meyer-Hill. They are the leaders of our Louisiana office. I closely work with them. I supervise them, and but they are the ones who are on the ground. Lauren is based out of Louisiana. Ashley was until a few months ago, and Sophia is in Tennessee. But most, if not all, of their work is Louisiana based. So we're glad that we're able to talk to you. I'm sharing their words with you today on special education rights in Louisiana. And this team that I mentioned actually is in the middle of litigating two really important cases in Louisiana. One of the reasons one of them or all of them couldn't be here with us today. Just a little bit about myself. I've been a civil rights lawyer for almost 30 years. I have worked with the U.S. Department of Justice Civil Rights Division, and I have engaged in advocacy with respect to voting rights, language access, Title VI, and some children's rights work, which I am now proud to be doing here at the Southern Poverty Law Center, where I worked for the last 5.5 years. So let's get started with respect to special education rights in Louisiana. As you can see, what from our presentation, we are hoping to provide attendees with an overview of their rights pursuant to the laws governing special education in Louisiana, public schools, depending on federal funding. This could also affect schools that are federally funded through grants. So I'm thinking about vouchers, for example. So it's not just a traditional public school system we're talking about here. Then we're going to talk about school discipline, the MDRs, also called. And finally, the fourth part of our presentation will be an opportunity for us to talk about questions that you may have, or comments with respect to what you're seeing, what you were observing in Louisiana. So let's get started with what the Southern Poverty Law Center does. I mentioned we have an office in the state of Louisiana, in the city of New Orleans, where in addition to children's rights advocacy, we also provide services related to criminal incarceration, and we have some economic access work that we provide, and voting, access to voting. So we have been around. Southern Poverty Law Center has been around since the late 70s, and we are committed to working specifically in the Deep South, although we do take on issues of national importance when where they specifically affect our communities in the Deep South. We have other offices outside of Louisiana. We have offices in Florida, in Georgia, in Alabama, where we are headquartered. We're headquartered in Montgomery, and in Mississippi. And I work out of the DC office. I like to say I'm part of the New South, but we do have a DC office. It's the only office that isn't technically in the Deep South. Okay, so I have asked folks, well, Sharon asked, but I am very interested in learning a little bit more about you all, where your interests lie. So I know some of you have kindly shared your name and why you are here. So that is all, welcomed for those who feel comfortable sharing. So I'll give folks a little bit of a minute just to say who you are. I see a couple of self-advocates. If you can share with me where you're geographically in Louisiana, that would be really important, just because we serve supposedly the entire state. We're very, a small staff, but we are interested to learn what parts of the state, we're seeing concerns. We have cases in St. Bernard. We have a case that is statewide, but we've also heard from folks in the northwestern part of Louisiana. Okay, yes, we do a lot of work in Jefferson Parish. Thank you for sharing that. Lake Charles, excellent. Thank you all for sharing that. Yes, so we, as I mentioned, would like to talk to you today about laws, federal as well as state laws, that provide protection for families who have children with disabilities, special needs, different abilities. And with respect to what we'll discuss, in terms of laws, the primary legislation that protects children who may need access to special education comes from the Individual with Disabilities Education Act, also known as IDEA. I would like to know, just, put a little note on the chat if all of you have heard about IDEA. It is a really important piece of civil rights law, and it is very helpful for you to at least recognize the name. So we have the IDEA. We also have what folks may know as the ADA, or the American with Disabilities Act. That act provides protection for children in public schools, as well as other accommodations, but we're focused on public schools here. We also have the Rehabilitation Act of 1973, which is most commonly known as Section 504. So Section 504 is related to the ADA in that it focuses on children who have physical challenges and who require additional support in accessing public educational facilities. Then we have state law. It's important as residents of Louisiana, for us to be aware that there are protections, not just at the federal level, right? But we have state protections under Louisiana code and law and regulation, such as RS 17 1941. That is the code and its subsequent chapters. It deals specifically with education for children with exceptionalities. That is what the state law calls what, for example, the ADA calls children with disabilities, what the IDEA calls individuals or children with disabilities. In Louisiana, the term is exceptionality. So it is good to know that in addition to federal law, the state law provides protections. There are state protections. Finally, in terms of where else can we as families, as parents, find legal redress, we also can look to policies in Louisiana in bulletins that are issued by the Louisiana Department of Education. And then the BESE, I'm trying to remember, I think it's like the elementary and secondary education, the Bureau, I believe, of Elementary and Secondary Education. So these entities, the Department of Education for Louisiana, as well as BESE, they issue intermittently, they'll issue bulletins with certain pronouncements, with certain legal commentary, where, for example, as you see, you can find an appraisal, the pupil appraisal handbook that they have issued, which helps families if there are questions concerning how students are evaluated, assessed, what regulations apply. Also, complaint management procedures. If you want to learn what do I need to know before I file a complaint against my child's school for failure to provide an IEP or to comply with IDEA, etc. You might want to look at some of the existing pronouncement bulletins, right, by the BESE and the Louisiana Department of Education. So we're going to first talk about federal law, where some of these rights arise under federal law. And just as an FYI, with respect to violations under federal law, you would raise concerns with the U.S. Department of Education, or depending on the question, on the matter of concern, with the U.S. Department of Justice Civil Rights Division, which is where I work. But let's talk about Section 504 and the ADA. So, don't mean to be moving this around. So you can see that Section 504 addresses access issues for persons, for children who have any disability that may substantially affect a major life activity. That would be what we call like the primary focus. Does the child have a disability that substantially affects a major life activity? And what 504 focuses, if the answer is yes to that question, what 504 then requires from the school district, in this case, from the school, is that the school ensure that there are services, accommodations, or that they make modifications so that the child has an equal opportunity to access the school. Okay? So this is important to note. If you have concerns about physical access, your child physically being able to access the school, or even get around the school and access their classes, then you're looking at an ADA or Section 504 concern. This is federal law, and this is the guarantee that a person, a child with disabilities is what they term it, can access a facility, in this case, a school where they are seeking to enjoy services, programs, and activities. So we, under 504 and ADA, look at actual physical access, right, to the facility. So that's what the focus is, not on whether there is access to the a particular plan, learning plan, or anything to that effect. Okay. Any questions on that before I move on? So we have next another federal law. It's called the Individuals with Disabilities in Education Act, or IDEA. I've been talking a little bit about IDEA. So IDEA applies to, IDEA has a specific, what we would call their specific jurisdiction under IDEA. It applies to children between 3 years old and 21 years old. Okay. With the ADA, there is no age requirement. With IDEA, there is. With respect to IDEA, you must have a qualifying disability in order for you to avail your family, your child, or your family of its protections. And we have included examples. They're not exhaustive, so these aren't all the qualifying disabilities, but there are some of the most common, including autism, blindness, deafness, hearing impairment, orthopedic impairment, speech or language impairment, etc. So IDEA focuses, unlike the ADA 504, IDEA focuses on ensuring that a child who has a qualifying disability has access to special education and related services. So here we're talking about the actual education and programs, services, activities that are provided by the school, as opposed to access to the actual facility. Okay. And IDEA works under a premise called FAPE, faith, which is the belief under the law in this country that children have a right to a free and appropriate public education. So the purpose of IDEA is to ensure that your child, regardless of whether they have a qualifying disability or not, has access to a free and appropriate public education. Right. IDEA has a term, other health impairment, in terms of qualifying disability. We will note that with respect to that term, other health impairment, it is a very ambiguous term. It's we wish that they had been a little bit more specific, but at the same time, we know that other health impairment could mean several different conditions, right? So we are talking about, for example, things that weren't necessarily mentioned in the earlier definition that I shared, but may fall under other health impairment. And those would include health problems that are significant, such as asthma, ADHD, sickle cell anemia, lead poisoning, and heart conditions. So these are more physical, some of them more physiological concerns, as opposed to emotional, as also mentioned under qualifying disability. But as you can see, it is a rather broad range of conditions that could be argued are qualifying disabilities under IDEA. So if you are in doubt, then I think that you can either ask the school for guidance or ask for an evaluation regardless, because perhaps there is a condition that hasn't been explicitly recognized before, but it would qualify as a qualifying disability under IDEA. The issue and the concern is that, you don't take yourself or your family, your child out of consideration. Always make the request. Okay. IDEA does recognize emotional disability, certain emotional disabilities. So under IDEA and case law, it would have to be an emotional disability that exhibits or shows one of the following characteristics for a continuous, a long period of time. And it would have to be to a degree that it affects the child's educational performance. It affects the child's ability to learn, right? So here we share about three factors that are considered in terms of making the case for particular emotional conditions to be a qualifying emotional disability under IDEA. I see that in the chat. Okay, there is a couple of things. Okay. I'm a parent of a child with dyslexia in New Orleans charter school. Okay, thank you. Yes. Thank you for participating there. Okay. So let me ask you all, if anyone's comfortable, is there a difference in terms of the protections that are afforded between Section 504 and the ADA and IDEA? And if so, what is the difference? What would you say is the difference? What would your understanding be? Feel free to, you don't have to come, on camera, but if you'd like, you can come off mute or you can share in the chat and I will read. Yes, huge difference. That's right. That's right, Ms. Patrick. Exactly. Anyone want to share anything else with respect to contrasting and comparing these, these very important civil rights laws that, that where we can find redress, where we can, exercise our rights. IDEA has money. That's a big one. There you go. Yes. Less accountability and less of a voice. What do you mean by that? In terms of less accountability and less of a voice, if I may ask, if you're comfortable sharing.
My daughter has a 504 plan, and I feel like because there's no money attached, it's far more difficult to accomplish things in terms of accountability. And then for a lot of things that are driven by IDEA, 504 doesn't have the same amount of representation, which I understand that you have to have an exceptionality to participate in some things, like as far as parent feedback and that sort of thing. But I know that it's money driven too. It's just frustrating because my child also has a disability.
Thank you so much for sharing, Miss Patrick. Yeah, you're absolutely right. Those of you who have noted there is a difference. Money is obviously a huge difference. But what I would posit to you, yeah, and this is what I was going to get at, Miss Johnson. Miss Johnson writes that Section 504 lawsuits take a lot more time than IDEA lawsuits, and that is correct. The way that 504 is set up, it requires a lot more involvement, for example, by federal agencies, whereas with IDEA, you can engage the local schools and have, use the law to move the process along much more quickly than with 504, where you actually require involvement, specific involvement from federal agencies that are often overwhelmed. That is true with other, concerns from all across the country. So the time of resolution, the way that money is attached. So as parents, strategically, where we can, although it is important, and there, obviously are processes to file complaints under 504. If the concern requires immediate attention. 504 may not be the best process to follow with respect to getting redress, immediate redress for concerns. Yes, I also see in the chat, while it is quicker in terms of getting redress and there is money with respect to filing complaints under IDEA, our Ms. Suarez writes that the criteria for IDEA is a higher burden of proof for parents to receive benefits. So, it's commensurate. You will be getting more benefits, and it might be easier to resolve concerns once you can avail yourself of the protections of IDEA, but at the same time, it is a higher burden of proof. We just quickly looked at what a qualifying disability is, and it is a complicated process. So, this is the concern, not just with children with, disabilities or differently able, but also with, for example, children who don't speak English. These processes are very complicated for most people. And there is very little support that school districts tend to give to help folks, avail themselves of IDEA, of those protections, because generally, the school will see folks who are trying to avail themselves, whether it's 504 or plans under, IEPs or any sort of IDEA protection, as almost threatening their authority, right? And that's unfortunate. But it is the goal, of our conversation today, to let you know that there are resources. If, for example, you are seeking some to avail yourself of rights under IDEA or 504 or any of the Louisiana statutes, we do have a hotline, and I'll share with y'all later during this presentation, so that you can talk to folks who can provide some guidance, so we can help each other, right? I see monetary compensation is available only through 504, is what someone wrote. Okay. Thank you for that. Okay, let me move on to, just quickly, I mentioned that SPLC was very we're committed to enforcing civil rights laws in Louisiana, and ensuring that families and children have access to a public education, right? A free and fair public education under IDEA, or access under 504, and also under Louisiana statutes. So we are engaged in a lawsuit against the state of Louisiana, the Department of Health, Louisiana Department of Health, because we are asserting that the Louisiana Department of Health is negligent in ensuring that children who are in need of mental health services through Louisiana Medicaid receive them. We are alleging that that is not happening, that the Louisiana Department of Mental Health is in violation of its own laws as well as federal laws. So we have a contact number. LA Kids Mental Health is our email box. If you have questions or concerns, if you or someone you know has a child who would qualify for Medicaid in Louisiana, and they are not receiving any support for their mental or behavioral health disabilities, because we know the state of Louisiana Department of Health is not meeting its obligations, then we certainly would encourage you to reach out to us. This is, we check every day with the mailbox as well as the hotline that we have, because we want to make sure that we provide the court with information, actual information about what is going on in the state of Louisiana with respect to, Medicaid and the failure of the state for providing children who are suffering from mental and behavioral, thank you, disabilities, with those services to which they're entitled. So that is a number that we share with folks in case you know someone who might be in need of consultation. We have our lawyers look at that hotline, and we reach out to people who call or who send us an email. Okay, then this is a slide that talks about the process for getting services and accommodations under IDEA or 504. So we can start off by saying, hey, you know, my student is struggling, my child is struggling. Then we as parents or the school can request an evaluation. So I think it's really important to know that you as a parent obviously have that ability and that, you know, that right to request an evaluation. But it's also important to note that the school, you know, staff, the educator, the people who see your child in a learning, you know, setting also can request an evaluation. And there are some times where you may not, as a parent, be able to pick up on some things, but the educator will be able to do so. So if, you know, there is indicia, there's any sort of indication that your child is not doing well, but you can't quite understand why that is, definitely, and we would encourage that you talk to the educator or you request an evaluation. But the responsibility lies also on the educator side. That's the point I want to make. Once an evaluation is conducted, then if there is a disability that is recognized by law, that is identified. If, for example, the evaluation shows that your child has a disability and that disability falls within the qualifying disabilities of IDEA or is recognized under 504, then you go through the next step, which is the team. These are the educators as well as the family, the child, should meet. There should be a meeting to develop a plan, whether it's a 504 plan, whether it's a plan under, you know, IDEA, then an IEP. Everyone should participate. That will be instrumental to ensuring that that child receives all the support they need so that they can access, just like anyone else, you know, the program services and activities that the public school offers. Okay, so what about evaluations? What can we talk about in terms of important points? If you request an evaluation, or if the school says, we really think you should have your child evaluated, then you have 60 business days for the evaluation to be conducted after the school receives your permission, right? So again, emphasizing that the school is also obligated, right, to identify whether your child might have a disability that is recognized. So it's not just, the burden is not just on parents. That's, you know, an important point. As a parent, you also, in addition to having the right to request an evaluation, you have a right to an independent evaluation that the school pays for. So if you don't want, for example, the school to choose who's going to evaluate your child, you may ask another provider, an independent provider, to make the assessment, to do the evaluation, and you won't have to pay for it. Okay, so that's, I think, a really important point. to emphasize. Okay, what is their breach? Okay, I'm just checking the comments. What is their breach, or what is it they are not doing or providing? What are they required to provide? Okay, would you like to ask a question? I'm a little confused about the question, Ms. Suarez.
Yes, thank you. Hi, I was just asking about the lawsuit. That was like a little bit back, so that's what
I'm
I was
sorry.
referencing. That's
I'm
okay.
sorry. I'm not checking these as the
That's
comments
okay.
as
It's
often.
fine.
Yeah, so the lawsuit, just quickly to tell you about the lawsuit against the Louisiana Department of Health for violation of the a children's right to, or a child's right, children's rights to access Medicaid services if they have behavioral disabilities, if they have behavioral disability. That is pretty much what we are suing the state of Louisiana over. We know that unfortunately in Louisiana, there are hundreds, if not thousands, of children who suffer from mental health conditions. And under the law, the state law, the Department of Health is required to make sure those children receive, free mental health services, access to, independent evaluations, etc., to ensure that their mental health needs are met. Louisiana is not doing any of that. They are doing the minimal, and in many cases, are not doing anything. So we are seeing parents, who call us in tears because they have children who are in mental, health crises. They've tried to reach out to the state. These children would qualify for Medicaid, but the state is not providing adequate, and in some cases, they're not providing any healthcare support as the state itself requires. So that's what we're suing about. And we're in the middle of this litigation. It's been ongoing now for several years. But again, it's a class action against the state. So if there are families who are going through these horrible circumstances because the state is not meeting its obligations, its Medicaid obligations, we certainly want to know and see if we can help. We sometimes refer people to resources in addition to providing, some legal assessment. So that's why we share that particular hotline. And again, it's an ongoing lawsuit, so we're taking calls, we're taking emails and reviewing those. So please let us know if you know anyone in that situation. Okay. For those of you who have never seen it, this form right here, that I'm not covering it. This form is entitled Request for an Independent Educational Evaluation. As I mentioned, you as a parent can request to have a provider that is independent of the school that you've identified conduct that evaluation to determine whether or not your child has a recognized disability and is eligible for the protections of IDEA. So just be mindful that this does exist. And if you have any questions with respect to the content or concerns about filling it out, don't hesitate to reach out to us at the hotline that we provided. We will get back to you. Okay, so little tip for folks. And this goes for folks who are interested in either a 504 plan or a plan under IDEA. We encourage you as a family to always put communications with the school when it comes to, requesting for, assistance for your child in writing. It is really important to make a record because if in the end you have to seek legal counsel or outside help, having a clear record of what has transpired, what efforts you've made, what the school has done, what school officials have told you, and their lack of responsiveness or All of that information is really important to have. So that is something that we encourage parents to keep in mind. Just write things down, make a record for yourself of what your efforts are and your communications with the school. Okay. As a summary, you as a parent have a right to an individualized education program, an IEP. Your IEP brings together the school staff, the parents, and in some cases the child, so that you all can work together. The goal of the IEP under IDEA is to make sure that the school officials are working closely with the parents and other professionals, other folks who provide support for the child, so that this integrated approach makes sure that nothing falls through the cracks, right? Communication is key. There are requirements in terms of meetings. There have to be annual IEP team meetings, or you may request a meeting after someone provides like the independent evaluation after the evaluation takes place. You also have a right to free copy of the results of the evaluation. So these are not things that the school can keep from you. You have every right to have a copy of the evaluation results after they've been conducted. Also, if the school needs to discuss any part of the IEP, or even when you are getting ready to implement an IEP, your child is getting ready to start, there has to be a meeting, and you must receive notice in writing from the school of anything related to the IEP. Likewise, you should also, as mentioned earlier, instead of calling, try to write emails to the school to ensure that there is a record of communications related to your child's IEP. And in cases where you call, just keep a record of the call. And, for example, whom you talked to, when the call was made, that sort of thing, what they told you. All right. So here we, just a little bit more about the IEP and what, you should expect, who should participate in these IEP, team meetings. Under the law, the following people must be there. You, right? The parent, the guardian, at least one regular education teacher. By regular education teacher, you probably all know what that means. It's not an educator who specifically, provides like special education. Also present must be one special education teacher, a school district administrator or their representative, and someone who can interpret the results of the evaluation. It can be the person who issued the evaluation, who provided it, or it could be one of the other 3 school representatives that are required to be at the meeting. Okay. Who else can come? You may invite, for example, a speech therapist or an occupational therapist that provides support for the child. Also, you can ask a therapist, social worker, anyone in your child's life who you think would be important to have present at this meeting. And as I mentioned, where appropriate, the student. If, that would be a call that you would make as a parent, perhaps with a therapist or a social worker, whether the child would benefit from being a part of that initial meeting or subsequent team meetings. But under the law, this is who should be present. And again, the goal is to make sure that nothing falls through the cracks, right? These are the people that should be there so that you can ensure that your child is getting all of the help that he or she is entitled to by law. Okay, with respect to additional considerations for IEP meeting, you should notify the school district in writing if you are limited English proficient, or if you are, if you need sign language. Under the law, the school is required. They have to provide you with an interpreter if your best language is not English, or if you are, if you are deaf. So if you need a sign language interpreter, or if you don't speak English, the school has to provide you with an interpreter, but you must give them notice. That's what the purpose of that particular note is. During the meeting, you may take notes, or you may ask the school to record the team meeting. That is okay. That is not a violation of any particular regulation. So if you are someone who prefers to have a recording, you may ask if you can record it, if you have your own recording device, or let the school know ahead of time to see if they're willing to record it on their own. And finally, this process, as some of you have lived yourselves, is immensely mentally and physically exhausting. So we understand that you will need to take self-care sometimes, and Lord knows I've seen this happen. There will be comments made that will be, hurtful, sometimes unintentionally so, and we may need to take care of ourselves and protect our sanity. So take care of yourself. Take a break. If things are getting a little bit heated or frustrating, take a break. Don't be scared to say, I need a break. So be mindful of that for yourself. Again, continuing with IEPs, what we suggest you do after a meeting, just to make sure that you are, again, keeping good records, and really doing everything you can to protect yourself and your child. You can ask and review, obviously, the IEP that they've developed. You should, because this is what will guide the way that the school provides services for your child. You have every right to object. If you don't agree with what the school is proposing in the individualized education plan, you can say, I disagree with this part, or I disagree with this particular section. And we suggest that you write the actual disagreement on the IEP, but it is important that on a separate piece of paper that you articulate, that you explain why specifically you don't agree with that particular section or portion of the IEP. Okay? And it's important also for you to ensure that the school has a copy of your reasons for disagreeing. So you need to obviously keep a copy for yourself, but you must ensure that the school acknowledges receipt of your disagreement with the IEP, if there is one. And I would suggest, whether it's using an email and asking for a confirmation of receipt, or whether taking things down. If you're one of those, old school folks that likes the paper, likes to take it down, make sure that you ask someone, whomever you provide the document to with your disagreements, to sign and date, not your your copy, but the copy that you're providing to the school. And just you keep that as proof that you have submitted your disagreements and concerns. What happens if there is an agreement with respect to an IEP, or if there is an existing IEP? What happens if they if the school violates it, does not comply with its own IEP? What kind of remedies are available for you to seek redress? Well, you can engage in traditional remedies that are offered under the law. Mediation, right? You can have a mediator come in to try to see if the parties can reach an agreement. You can have a facilitated IEP team meeting where it's similar to mediation, where you could perhaps bring someone of trust, an educator, an administrator, someone from perhaps a legal advisor to act as a mediator, or facilitate a conversation between the family and the school administration. You can file a formal complaint, whether it's under IDEA, or if it's a 504 complaint, you could file, a 504 complaint. There are formal complaint processes. You all have brought up the fact that in some cases, it can take a while, depending on who is looking into the concerns. It could be a while before you hear if you file a formal complaint. You could request a due process hearing. Those are fairly expedited, but how many families feel comfortable on their own showing up at due process hearings? So we do work closely with resources in New Orleans. We work with the Loyola University Legal Clinic. They have a clinic that represents families in due process hearings, especially where their child is facing expulsion, or their child is facing a transfer from the place of, their normal place of education to an alternative school, or a more punitive setting. So there are resources of lawyers who have, for free, pro bono, provided services to families in the New Orleans area. I'm not sure, whether those services would exist outside of the New Orleans metro area, but again, you can also do this on your own. You can contact our hotline, and what we could do is we could try to talk to you and figure out what a best way to present your concern would be. We unfortunately don't have the staff to provide representation. That's why we closely work with Loyola and we provide referrals to them. But yeah, in terms of actually going through a due process hearing, ideally you would want to have some sort of legal counsel, or at least talk about it with a legal services organization is what we would suggest. And you see there is additional information on dispute resolution. If you could, take a look at it, I'll send the link when I share the slides, okay? I have, what would the law say about staff not wanting to be recorded when you ask them to record the meetings? So what I would say in that case is that it is your understanding under the law that you can ask for the meeting to be recorded. And if, the staff says, I don't want to be recorded, then what I would do is I would have the school prepare something in writing right then and there, explaining that I would identify the staff member, and I would ask them to say why they don't want to be recorded. So you immediately get that in writing, and you have that in hand in case that there is a concern. And, frankly, I would also say, the reason why I'm asking for things to be recorded, one is, obviously for my own edification. I would appreciate being able to fully understand what goes on, and I'm afraid that I'm going to miss something, but also to protect my rights under, federal law. I would throw that in there too. Because that is why there is this, right to have, or you have the, right to ask for the proceedings to be recorded when you're doing that team meeting. Thank you for that question. That's a very good question. And I'm sure it happens more often than not where people don't even mention that, they can have the meeting recorded. Do you have to register your own disability or provide documentation of disability if you request accommodations? Yeah, so under 504, you have to show that you meet that you're disabled, right? With respect to providing documentation, the and I think one of you said this, the onus of doctor note. If you have, I'm just trying to, ideally, it would be some sort of doctor. Most of these conditions there's usually well-established medical to include it, as long as your doctor can provide some form of acknowledgement. That should suffice. And I guess on the type of accommodation, they may ask for additional information. Should not upset or lead you to think that it's going to be onerous. But if you are if you provided sufficient information in your opinion, then I think the next step would be in all of this should ideally be in writing, right? We want to make a record of what's going on. So I know it's sometimes a pain to write the email, but every exchange of information, documentation should be in writing. And if the school continues to ask for additional information, that is where I would say, under Section 504 of the American, Disabilities Act or Rehabilitation Act, I'd like for you to articulate exactly what you're looking for. What exactly do you want me to show? And do it in writing, and I bet you that things will get resolved really, really quickly. So here, ODR statistics is something close to parents prevailing 12. Oh my goodness. That's for the due process hearings, really. Yeah. And this is our concern. And this is what I've seen in my short time working, in Louisiana. We are very lucky, the parents that we have, whom we're able to successfully refer to Loyola, because Loyola wins these due process hearings. They win them. But if you're telling me 12% of, these due process hearings, end up favorably for the parent, that means that so many of us don't either, have access to legal counsel, certainly cannot afford to bring legal counsel to these meetings. So when I tell you that if you have a due process hearing that is upcoming and you reach out to us and say, can you just take a minute to talk to us? We'll try either to talk to you or refer you to some of the resources that we have, because it is really important for you just to talk it out with someone. And yeah, thank you for sharing that. That is truly disheartening. And it again reflects the fact that these processes are not, it seems, meant to really provide the help that our children need, the support. It's almost as if only the strong will survive, and that's not the way it's meant to be at all. So I commend you, parents who are here and who are fighting and who are sharing information with others. You truly are the heroes here. Okay, I see another question. If you sign an IEP at the annual meeting to revise as your accommodations and or services have been forthcoming about, oh wow. I believe that you can request upon learning of either a change condition of or learning about resources that were available, but the school somehow failed to provide available to child. You can request, I believe, just one time. So it's once during a year period, if I'm not mistaken. So you have or you other meeting to revise the item. If, for example, 6 months later, within that same year period, something else happens, under the law, I don't believe you can request a second meeting. So they allow you to do it once, I believe, and I'm gonna get back. If I'm wrong about this, I'll need to let you know. But I don't think that you can make multiple requests within a certain period of time, but you can make an initial request. I had a kid, but this is in Mississippi, not in Louisiana, and they do have different requirements there under their state law with respect to, because the state can provide more protection. So then the state law, we would look to the state law with respect to certain evaluation assessments, etc. In this case, it was only one evaluation, and you could request a reevaluation, but it would have to be not more than one within a 12-month period. But I am not sure whether that is the case here in Louisiana, but I can find out. Does anyone, Sharon, do you know? I don't know if Sharon's listening in, but I'm just
Ma'am.
wondering if anyone knows exactly what. Yeah.
I'm sorry, tell me again.
Oh, yeah. So once you've had the original IEP issued and you find out that there's been a change that would allow for more services to the child, I know you can request a reassessment or a reevaluation, but I don't know like whether it's just once within a 12-month period or if you can request more than one within a certain period of time.
If you disagree with the evaluation, you can request one at public expense, with, for that evaluation, but you can only request that once per evaluation with which you disagree.
Yeah.
Are you talking about having things added? I'm not understanding quite what the question is.
I actually, the question I think is fairly clear in my mind. I'm not sure about the response and I don't want to mislead, Miss Kylie. The question is you have an IEP that you sign, but then you later learn during later in the school year that um, the school has additional resources that can support your child, but the school was not honest about the existence of those resources. But now that you're like, well, I want my child to have access to these resources. So at that time, I would say it's a change in condition, and you can request, obviously, a reassessment. You can, write. We talked about, okay, if you disagree with the initial IEP, you can note your disagreement. You would provide the reasons in a separate, document. In this case, I would say that you can write a separate document. You can disagree, you can ask, given the new information that would, directly affect your child, the new resources that they would be eligible for. You can write something and ask for it.
Yeah, I
My
don't think
only
that would require a new evaluation, though. If your evaluation is accurate, but the resources are the problem, I think that you can just reconvene the IEP and say, I want these things added. That would be the first thing I would do. If the evaluation itself is not in question, nothing has changed with your child, then you can just reconvene the IEP and add services.
That sounds absolutely correct. Yep. Thank you, Sharon. Sorry that I had to drag you.
No,
Thank
it's
you.
fine.
Sarah, does that sound right? Just wanted to make sure that we address your question. Yes, it is a living doc. Thank you, Melissa. Yes. Yes, so IDEA is federal law. However, under the law, each state can expand rights and make, for example, IDEA. A state can on its own say, well, we have the IEP, but we'll go one step further and provide additional protections, etc., modeled after the particular federal law. What states cannot do, thank goodness, because I'm sure they would try in certain parts of the country, is take a federal law and cut away some of its rights. That's something they cannot do. But you can have a state add additional protections to like existing federal civil rights laws. Okay, I'm sorry. I just noted not all areas of the state have access to Loyola. I know. Yeah, I'm sorry. You're from Southwest Louisiana, Lake Charles, I think. Is that where you're from? And you're right. There are deserts of they're legal deserts, is what we would call them in certain parts of the state. The good news is that even though you may not physically be able to get to Loyola, what we can do is we can put you in touch. I mean, the law is the law, right? Right. And we can share information from, that they provide, or share resources that they may have, in terms of, trying to help you prepare. So I understand in terms of having, physically a resource right next to you, or a resource close by, but we can try to at least provide guidance. Rachel, please ask your question. Yes, you have a question.
Hello,
Hello?
can y'all hear me?
Yes.
Okay, I'm sorry. I'm at work, so I was like, man, they probably got to me and I missed it. But I really wanted to ask real quickly. My son is in first grade. He has IEP, and I'm actually about to go over it with a fine-tooth comb whenever I take my break. But whenever school started, which was last Thursday for him, he didn't get any papers like meet the teacher or anything like that. He is having his same special education teacher. So this past Monday, I was like, well, maybe they're gonna put, papers, homework, whatever, in his school bag, but I received nothing. So that Monday night, I wrote a list of questions for a special education teacher. And on Tuesday, she answered me. I asked who was his inclusion teacher, who was his paraprofessional, who was his resource teacher, and what days he was doing speech. So the answers I got back for the resource teacher was that at this current time, he does not have a resource teacher because they're too busy. And I'm like, what? Like, I've never heard of that. So I wanted to ask you guys if y'all have ever heard of such nonsense, and what do I need to do, I guess, moving forward? Because I am going to go over his IEP just to see if they have that in there. But I've never heard of resource teachers being too busy to service a child that has IEP who had a resource teacher last year. So I know that's a lot, but that's my question.
Thank you, Rachel, for raising that. I am so, so sorry. Unfortunately, I have heard of, these types of situations that are shocking. Let me ask you this. Are all of these communications via email, or did you call? Is there any sort of, record
Oh
of?
no, I've learned before to have a paper trail. I
Mhm.
actually have the paper trail of her saying that they're too busy. So yeah.
Wow. Well, that makes it easier in terms of you asking for a reconvening, a team meeting. And during the reconvening, I would present, obviously go through the IEP, right? And make sure that you have, that you take down all of the provisions, all of the individuals that are supposed to be a part of your son's education plan, and make sure that when you meet with these, request a meeting in writing, right? Let them know you are going to meet, that you want to talk about, I mean, do it now because it's the beginning of the school year. And, share with them during that meeting, the shock that you feel when you reach out to a staff member who's supposed to be supporting your child. If in fact, that staff member is on part of the IEP team, and that's just your shock in terms of their response. And I would tell them that you've talked to legal counsel in terms of just trying to assess whether this is something that should be happening, and clearly it isn't, so that you are asking the school to take whatever necessary steps are required to make sure that your child receives all that is due to him within the IEP. And if that does not happen, that you are going to you know seek to avail yourself of additional support, because this is just the beginning of the school year. I can't imagine what will happen later on when things get really going, right? When school gets really started. It's unacceptable. But I think your first step is to call for a convening, and to lay bare what this person told you, because that is inappropriate. And I would welcome any other any other thoughts from our friends who are on the call.
I mean, I'm stunned, but I would file a state complaint because it's a substantive like failure, and then that way she'll get an answer within 60 days
Yeah.
and it will be on point. Sorry. I'm outraged about that. It's not even my child.
Melissa, you should be
Okay,
able.
so I'm not crazy. I was like, I couldn't believe it. I was like, wow. Okay, thank you guys.
I know that in our situation, sometimes IEP services like related services and things don't get started right dead on the start of school because they have to get schedules arranged and things like that. So like speech OTP, even like APE and things like that may not start immediately, but they only need maybe 10 days to get all that going. And in the case of a resource teacher, if that is a block of time where the child is going to be going to resource, that
Be
should already
happening.
be set up. It's not like speech where they're going to have a certain schedule where they get pulled or the speech therapist comes in.
Wow. That in, right there, I think Melissa, with respect to the state complaint providing a timeline, I think you're right on about that. Because it does seem like this is unnecessary. And it's important for you to let them know this early on before things get, further into the school year, that you're not going to put up with that. So I think you've gotten incredible advice from Melissa and Sharon. And if you are willing to file the state complaint, just know that there are protections against retaliation where you file both under ADA, IDEA, pretty much any civil rights law will have an anti-retaliation provision. So do not be scared to file or to even seek redress directly if you're not going to file right away right now. You certainly can approach them without fear, right, that they're going to retaliate. And if you feel there's retaliation, then do reach out to us. At the end of this presentation, there is contact information. I also will share it, as I mentioned. I'll share a PDF with Sharon, but we have a hotline actually. And, if you reach out to us here, I shared it earlier, the 1-800-358-2337. And the email is lakidsmentalhealth@splcenter.org. We check that box, that email box. We check the voicemail every day. And we provide, guidance where we can, but everyone receives a call. Okay.
I was just mentioning in the comments that filing a open complaint with OCR, which is the Office of Civil Resolution, will kind of like protect you so that if there is any type of retaliation, if there is
Yes.
something, they have an open case, and therefore any actions they take that could be construed that way. They even have a box you can check that says, I'm opening a complaint and I'm afraid of retaliation. I had to do that for my kids.
That's an excellent point. The filing of the complaint itself will protect you. But even availing yourself of a right under the law, even if before you file a complaint, right? Even if you're just saying under Title VI, under the ADA, under 504, under, IDEA, that in itself gives rise to an anti-retaliation protection. So, but filing a complaint certainly will kill two birds, excuse me for using that expression, will take care of two things. One is you'll have a timeline, right? As Melissa points out, under which they have to, reach some sort of resolution for you. And that's the 60-day timeline that you mentioned. And you're also going to have in writing the fact that you've availed yourself of your rights, and they may be retaliating in violation of those rights. So one thing, students with disabilities have more protection from suspension and expulsion than other children. So your children, this is another case that we're actually handling. it's the placing of children with disabilities in alternative schools in a punitive type of setting, in many cases without regard to their disabilities, and that is against the law. So, there's so many things that are going on in terms of children with, disabilities or, differently abled. There is a 10-day rule. Students with IEPs or 504s may be disciplined, but there is a special protection, as mentioned, for students who are under an IEP or 504. If your child is, let's say, suspended for more than 10 days, that is considered a change of placement. And when that happens, that is absolutely not permitted without, and there's a process that the school must follow. They can't just tell your kid, you're suspended, we're going to expel you, we're going to transfer you. When that happens, you have additional rights. So be aware of that. And if you want to know more, feel free to contact us, okay? The other thing, here we go. Those are the manifestation determination reviews. So that's the process that the school must follow when it tries to punish, expel, or in any way, try to change the placement of a child who has a 504 plan or an IEP plan, or an IEP, excuse me. Now, with respect to those, we have a discussion here for purposes of this training. Just know that the purpose of this particular meeting, this manifestation determination review, right, is not to discuss whether your child engaged in a certain conduct, whether what the school alleges happened, but it is to determine the following. Was your child's disability what caused the engagement in, the behavior or the incident? Okay, was there a direct or substantial relationship between the child's disability and what happened? And was the conduct in question directly a result of the school's inability to provide adequate resources to your child? So those are the two questions that you should be discussing, not whether your child engaged in any sort of, wrongful behavior, but whether the school had a responsibility that they did not meet to help your child and avoid this, or whether your child's disability is such that it resulted in, the particular incident or conduct or behavior. So that's important because the burden is significantly different than trying to prove whether, an act occurred, or not, right? And who's at fault and who isn't. The focus is very, very specific, very narrow. Okay, we're almost done, and I think we're over time. So I thank you all for bearing with me, and I've learned quite a bit from you all right now from this engagement, and I hope we can continue to do these and have my colleagues also join who have a lot more experience than I. But what I do want to say is, we've engaged. This is the type of conversation with community that we hope we can continue to have. So for example, folks, who are not close to the greater New Orleans area, and you want, whether it's, one of my colleagues or I to talk to people in your part of Louisiana, let us know. Let us know and we'll try to make it happen. And if you have concerns, it doesn't matter where in Louisiana you are. Feel free to call our hotline or to email us because we serve the entire state. There aren't many of us, but we do our best, okay? And as I mentioned, we're specifically right now litigating cases dealing with mental health support, with alternative school placement of children with disabilities, the punitive, the punishing of our children by taking them out of, these schools and putting them in places where they don't receive any programs, access to programs or activities, any, additional educational support. So we know there are a lot of things happening, but we have hope I'm just in awe of all of you. You're warriors, you're knowledgeable. You're your family's best defense, and we're here to try to support you the best way that we can. So I really thank you for your time. I am going to share the slides with Sharon so that she can share them. But here, if someone quickly wants to have, the QR code, we have additional written resources and tools. We have sample letters for those of you who want to share or even, use yourselves. And I just want to thank you. And thank you, Sharon, for bringing us together. I'm sorry I went over, but this conversation was truly enlightening, and I appreciate everyone's trust and they're willing to be forthcoming. Thank you all.
We appreciate your time very much. I did drop the link to the little brief survey for everyone. If you wouldn't mind clicking on that to open it before we leave. And you will have, I will send out the PowerPoint when Luz sends it to me, and you will have her contact information there if you need to email her with clarification questions or anything like that. So thanks for being here, everybody. Thanks for your questions and your interactions and your expertise, because as I think you have found out, you are a vital part of your child's IEP team. You know your child better than anyone, and you're the expert. So thank you for investing yourself in learning about the laws. That's your first line of defense and your best way to advocate for your child's educational success. So you guys have a great afternoon. Luz, thank you again.
Thank you all. Thank you all.